must be something with old lawyers. When I was in law school 10, 15 years ago, no one who was a law lecturer could use any of the technology or any of the PowerPoints. And I always used to sit in class and think, oh, I could always do this. I won't be one of those professors who doesn't know how to use the projector and doesn't know what PowerPoint is and can't turn on the computer. And then 15 years later, I have the same problem. So alas, it goes in a circle. What we'll do to avoid this problem, I think we'll be able to get it rectified for the next class. There's one more YouTube. Needless to say, we are not going to click that because that creates a disaster and the computer explodes. So we're just going to tell you about it, and you can click it on your own time if you're curious about it. I assume many of you have already seen that movie. It's pretty popular. So let's just dive back into the content. So the funny thing about the scene with Winston Wolfe is it distills kind of the great elements of a planning attorney, a transactional attorney, in one sort of clever Quentin Tarantino scene. So someone from Medium online magazine sort of wrote how he displays these sort of classic leadership qualities, and they're perfect for estate and transactional practice. So these are sort of my tips and things to think about as we go through, because again, like we talked about at the top of the hour, is that this is a transactional practice dealing with death and taxes. So these are some good tips. So the first thing to think about as being a transactional lawyer and a planning lawyer, unlike, let's say, a pure advocate lawyer, you start out, have to be the calm, cool, collected voice of reason, the counselor at law. And as I said, your client's going to be disclosing extremely intimate, personal details, the facts of their life to you regarding their wealth and mortality. So some stories that I had in real practice, the number of times where you have to be the lawyer and someone comes in and describes a scenario that you'll sort of never believe is quite high. Most people see lawyers because they can't handle it on their own. So when I was in law school, I used to think, oh, these are the unusual cases. I'm never going to really deal with that in my practice. I'm going to get the regular old, sort of will and trust every day. And you get a little bit of that, but you get a lot more of something that requires creative thinking. So some examples. I had a client come in, individual man, client, high net worth individual, and we're doing the interview, and we say, "Are you married?" He says, "Yes, I'm married." And we say, "Have you been married before?" And he said, "Yes, this is my fourth wife." And we of course ask, "Okay, how did the other marriages end?" He said, "Oh, they all ended in divorce." So, "Ooh, and where?" And of course, all in California. All community property states, so there's a problem. I say, okay, this is getting a little more complicated. And do you have children? He says, yes, I have 6. I said, okay, you make an assumption they're from the marriages. He says, oh no, none of them are from the marriages. So I have 4 wives and 6 children, none of them are from the marriages, and the estate's probably in the $15 million range. That's 10 contentious litigants that are potentially going to be attacking this estate. So again, you're kind of do the interview, stay calm, cool, and collected, but then issue spot. Another very common thing, we do a lot of planning for international persons, high net worth issues, the concerns that they are here, your client, and the family that they have created here is the second life. Very common. That's a planning twist. Very common with high net worth individuals, Hong Kong, China, PRC, Korea, Singapore, Japan, France. I've had that more often than not. And Italy, you have a very complex, you do not have the situation that you think. Another thing that one has to be attuned to and just part of the planning lawyer, LGBTQ plus issues. You're going to have those issues where you're going to have to plan for LGBTQ families. You're going to have to address how that works and how the law applies to the relationship that they're in or the way that they want to handle their life. I have a client that he's from abroad. He lives his life in America as an out and about gay man. He approached me with the planning. He says, it is my mortal fear that my family in my home country figures out that this is the way that I live. I want my plan not to be designed that way. And that's your role as the attorney, so that you have to counsel this person to arrange their affairs to their preference. The other thing that's another major problem or challenge in this area is they're going to tell you how much money they have, where they got it, and it's not always from okay sources. And you're going to have to deal with, are there tax problems with this? Are there money laundering problems with this? Where is the ethical line between me being just a regular old estate planning attorney, and am I perpetuating money laundering? Am I part of some huge fraud? That's going to happen. This is the kind of funny story. This is a whole lot easier in rural Wyoming. It's a lot harder in Silicon Valley, California, because we have a diverse, high net worth, complex client base. You can't own a shack in Northern California without being $500,000. So we have a lot going on in our estates. The other thing that's back from the Winston Wolfe guide here is assess the situation. One of the key things for good transactional lawyers, and especially planning lawyers, is that you have to gather information. There's going to be so much information that you're dealing with: identity, preferences, all of this you have to gather, and then you have to translate this into black and white, into a will, into a trust, into a structure. So assessing kind of what's going on here, very, very important. Also, in another situation, if you have clients that are sometimes older, you're going to have to understand, son brought in parents in the 80s or 90s. What's going on there? Do I have to investigate this? Is this okay? Did he just drive her? Or is there some sort of undue influence issue going on? Again, attorney as counselor, you have to look behind all of this, because the face of what's happening may not be true. The other thing that Winston Wolfe does, take notes. Two things. One is, of course, we were talking about assess the situation. You need to know what's going on. You're going to be getting hit with a lot of facts. The other thing is, so one is, of course, to prepare for the documents. The other thing is, especially again if you deal with older clients, but anybody really, is keeping contemporaneous notes of the relationship, what happened, can be very important if these documents really, something goes sideways, and there's a question of what was that person's mindset at the time. When you met the 95-year-old testator, did the person, know what they were doing? Were there concerns about capacity? And when you have the notes, you say, okay, May 20th, we met, the person drove on their own, the person came up in the elevator on their own, we discussed, the will, we discussed the trust, we had a lively discussion, personal things. They told me about their, I have a client that likes to tell me about the small dogs and things. You have some notes, and that later, 10 years, 15 years, 20 years later, you can refresh your recollection about the situation. Because again, if it gets challenged, the odds of you remembering a 20-year-old client are pretty low. But if you have a good notes file, you'll be all right. Prioritize. This is very interesting. If you watch Saul Goodman, Attorney at Law, Alpine Shepherd's Boy, the funny thing is, it's a comical show. People have an unusual obsession with these Hummel figurines. It's actually a real thing, and people really do care about them. I've actually encountered this. Things that matter to the law and things that matter to your client may not necessarily be the same. Some things are, as a matter of law, very urgent. Some things are very urgent to the client. And you always have to kind of balance these things of what the client wants. They're going to be focusing, on and on and on about the Hummel figurines, and then forget that they own a hotel and say, well, the hotel you just divide it, but we really have to deal with, for you as the lawyer, maybe you're going to really concerned about the hotel. You really don't care about the figurines, but your client cares about the figurines, so you're going to have to balance. This is another. We're going to go into delegate. This is delegate in clear directions. We're kind of hitting the same thing. This is another different area in that you often work with other professionals. It's quite different than pure advocate, though. In advocacy, you'll often deal with expert witnesses or things like that. But in estate planning, working with other professionals is nearly ubiquitous. You're going to be dealing with the insurance agent, the financial planner, the accountant. The odds of you getting in a fight with an accountant is like 100%. The accountant saying that they know exactly what they want to do on every single thing and they're in charge, and you saying, no, you're not. Them trying to sell, a business entity or estate plan that they sort of holly-hobby up is going to happen in your practice, because CPAs think that they know everything and they resent lawyers. I just, it happens a lot. So you have to, again, exercise some depth, skill, so that you can work with these people, because the client may be from that CPA. So again, you can't just burn bridges. Again, as advocates, we could just say that, nuts to all of these people, we're fighting out the case. That doesn't work in estate planning, because the client also likes the CPA. So you need to somehow make this work. You're going to have to deal with real estate brokers. You're going to have to deal with appraisers, all kinds of different people. So delegating and then giving clear directions and saying, okay, I'll be in charge of the legal plan, I'll be in charge of the structure, find the tax returns, and let's say the valuation will be done by the CPA, insurance will be designed by the insurance broker, the financial planner will handle how they handle the portfolio, and we'll kind of work together, and you're going to quarterback this thing. You have to do that, because some areas of law, this is less common. You don't have to work with these other people as closely, or the people very quickly understand that the lawyer is in charge. And you may be thinking, well, why do I have to be in charge? The Bar Association makes you in charge when you're designing the plan, and hopefully you're carrying malpractice insurance. People tend to point to you when things go wrong. So you need to make sure that when you're designing the plan and you're doing it right, you've given clear directions, you've sort of delegated, everybody knew their role, and then when somebody doesn't follow it and it goes wrong, you have the clear documentation that, well, they didn't follow it. They started listening to the CPA and did something silly. So that's very, very common in this area. The last two things, be firm. This is a quote actually from Judge Weisbrod, who's a San Jose bankruptcy attorney or bankruptcy judge for years, and was someone that I studied under in law school, and then was his clerk. You're a lawyer, not a butler. So your client's going to want you to do all of these different things. You need to sort of draw the line of where you are as attorney, as counselor, not butler. And the irony is sometimes the better, sort of quote unquote, better client you have, the higher net worth, the more sophisticated, the more they, honestly, the more they spend on legal fees, the more demanding they're going to be, the more difficult they're going to be, and you're going to start getting these ethical problems coming at you pretty quick. And you're going to have this problem of, how far can I go on this? What can I do on this? And I really don't want to lose this client. So this is the reality of practice. We're going to be getting into the ethical rules in a moment and how to apply it. But a lot of these things, which is kind of funny, the ethical rules are a little bit more simple when they're the prosecutor, you're the defense attorney. Of course, I'm not going to disclose anything. Of course, I'm not going to talk to anybody else. Of course, I'm just going to go into court and present my case. It's a lot different when the whole family shows up in your office and says, we're ready, willing, and able to pay. We want to hire you. Let's go. We all get along. Look, we all get along. And then you actually have to be firm and say, wait a minute. You all, okay, who's going to be the client? Mom and dad? Okay, you come in. All of you out. Okay, mom and dad, we're going to, this is confidential, this is privileged, we have to talk about this. Mom and dad, husband and wife, potential conflict of interest, because I'm going to be representing you jointly. Surprisingly, or the surprise of no one actually, husband and wife, tense relationship sometimes highly fraught. So we actually have to be clear that currently I represent you both. Maybe eventually, if there's some problem, I have to withdraw. You have to start doing this because these issues come up quick. And then the last one, and this is, again, I think is the most important one, and I save it for the last, which is very different than I think some of the other classes or the other areas of law. You being empathetic, you being human, you being a good person, that's aside from your legal acumen, the most valuable tool that you have. You're going to be dealing with clients and dealing with people expressing extremely intimate things. Like I said, what happens when you die? What happens when you're incapacitated? Where your money came from? Your relationship to your children, relationship to your other family. They're going to be opening the bag and telling you this. So you need to make your office, the way you do, you practice your service in an empathetic way that they can use your service well. This is another risk. The client's on the fence about you, doesn't really trust you, and they start to withhold facts. And what happens, you start to poorly plan because you don't think, former spouse is going to be a problem, and then you realize, oh, former spouse is going to be a problem, or a child who's disinherited is going to be a problem, or there's some financial problems that you say, oh, these funds are probably all clean. Of course, we'll transfer them to a Wyoming trust, to a private trustee, and then all of a sudden, whoa, all of a sudden all these tax problems poured out of it. So this skill, which, again, you think of like, personal injury torts, fighting each other, empathy to your client, but then, towards the other side, you're pretty tough. This is a little bit different because there's not generally going to be another side. It's going to be just your client. So being human and being able to engage with your client and understand and have some tact and empathy and approach them in a way where this process is a comfortable and, how should I say, a process that they can, I'm not going to say enjoy, but a process that they appreciate the process, they appreciate going through it, and they understand why they're doing it and the direction that they're going. So this is just a few tips, as we saw from the Winston Wolfe thing. So we'll skip over this. So we're going to pop into ethics in practice. Before we pop over there, do we have any questions? I'll open up to any questions that anyone has. Or see some shakes of the head. Okay, so we'll move right on. So ethics in practice. So we're going to talk a little bit about the California Rules of Professional Conduct. So we are going to look at these. So a little bit of supplement to your legal professions class, and a little bit different because when I think back to my legal professions class, is taught by litigators about litigation, and they used to love the cases of, which you probably remember, of I'm the defense attorney, and the bloody knife is in my client's car, sitting at the curb in front of my office, and I'm caught in the ethical dilemma. You're not going to encounter that in estate planning practice, but you're going to encounter a lot of ethical potential problems that are going to happen sort of quick, but at a very low level. And that's actually the biggest ethical trap, is little small ethical problems. And then these little small ethical problems accumulate and then start to snowball, and then something happens. And then you have quite a problem. So ironically, for example, I practice bankruptcy law and insolvency law, commercial restructuring, consumer restructuring. Very few ethical problems come up because it's very clear sort of what the roles are, and you often have outside professionals, accountants and things, and you are planning to disclose everything to the court in a bankruptcy proceeding, or you've already given a lot of disclosure due to dealing with creditors. So you don't really have a problem as much with these things. But estate planning, you tend to see it a lot. Also, estate planning is generally practiced out of a smaller firm. So you don't have a whole superstructure that kind of avoids, you don't have, I worked in large firms where you have conflicts counsel. So when you get the case, it's already been cleared for any conflict. That's already been done. For diligence, you have, 200 years of experience of all of the other partners and all of the other associates. It's, very easy to avoid those problems. This is generally practiced smaller, so a lot to watch. So we're going to talk about a few of these rules. So one of the first ones, obviously, is competence. You have to know what you're doing. And, of course, we see the rule, lawyers shall not intentionally, recklessly, or with gross negligence or repeatedly fail to perform legal services with competence. How does this come into estate planning? Classic one, two issues that I see where this happens all the time. One is very large estates. If you're dealing with an estate and you're a relatively new attorney or with not so much experience, if the estate is over $10 million and there's going to be an estate tax problem, you better watch out. Because unless you know that tax really well, you could have a massive collision. Anyone know the highest rate for the estate tax? What's the estate tax rate for the highest margin for amounts over $1 million? 40% now. So it's a 40% tax. So again, if you have a $15 million estate, now we'll use the post-2025 exemption. So let's say a husband and wife is $10 million. You have $5 million less $1 million, $4 million at 40%, and you made a mistake, and they're going to lose, $1.6 million. Someone's going to be really upset. They're going to want that malpractice policy. So there's a classic one where how to practice well in this area is understand the client that's a suitable client, understand the kind of the profile, and then when you have clients with other practice profiles, you kind of know, I better associate with someone, I better see someone on this because my ideal competence area is this kind of client. So high net worth is a problem. The second problem that's a massive problem and very, very common here is you have international families, and husband is a non-US person, non-resident alien. Wife is a green card holder, and they purchased a property with joint names, and they want to do an estate plan. We know the estate tax exemption right now, actually for one single individual, it's actually about 11,600,000, but it will go down to 5 million after December 31st, 2025. What is the estate tax exemption for a non-US person? You can use it chat if you want to tell me, or you could unmute and shout it out if anyone knows. $60,000. Highest marginal rate, 40%. So you have that situation and you do a regular old trust. If husband dies, they're going to lose 40% of that half. Big mistake. So again, you can kind of see your client profile. Ooh, in my questionnaire, in my sort of intake, I need to check for non-US persons because there's a whole analysis I'm going to have to do, because otherwise what's totally competent and totally right for all of my other clients will cause a disaster in this other case. And you only need one case to go sideways. So this is kind of the classic thing with competence, is estate planning initially seems not so complicated, but then as you get different client profiles, different issues coming up, it can be a problem. The other classic one that's very common is that you have your second marriages, stepchildren, all of these things, dealing with H-1B people who are temporarily domiciled here for the estate tax, but then are going to leave. Whole host of issues, which we'll be talking about. Next one is, of course, diligence. This is one that's fairly easy, to deal with, through creating good office practices. Is, of course, keep your client updated, and this is a major part. It kind of goes with diligence and competence, and actually a little bit about communication. It's important to sometimes go the extra mile with a lot of these clients to make sure they understand the plan. You do want your client, when they do a trust, to understand sort of the basics of why they did the trust. Again, especially for clients that are older, it's critical to determining capacity that they are able to give you a brief understanding of what this is. Even if they say, I don't really want to go through probate. I'm kind of have a decent amount of money. I may get dementia. I would really prefer my wife and then my children manage it, and I don't want to go to court. That's enough. But you do need to go through the explanatory process so they know that. Communication, of course, that's pretty easy. Of course, keep them apprised of what they're doing. So, continuing right along here. Whoops. Oh, so those are pretty direct. The next one's another one, sort of like competence, that actually is complicated again. Confidentiality. Again, in the litigation area, you generally, you're sort of in the middle of war there, you're not going to accidentally disclose something, but you're going to get confidentiality problems approaching you really fast in estate planning, because again, the duty of the lawyer to maintain inviolate, the confidence, and at every peril to himself or herself to preserve the secrets of his or her client. This actually, I have an asterisk on this. If you read Rule 1.6, this is not the rule. The rule actually refers to the Business and Professions Code, and then it's sort of cross-cited. Again, when they redid the rules just a few years ago, why they didn't just put this directly is kind of bizarre. But alas, that's the way the rule is. So if you look for 1.6, it's not going to say this. It's going to be in the notes. So this is a major, major issue with estate planning for a couple of things. Classic one is people come together. You often have parents and children come together. You're going to have parents and their parents, so the grandparents are there. You're going to have problems sometimes. Here's a classic problem, is that people will ask about the plan. That one's kind of easy. As an unsolicited person, not the client, you just say can't disclose anything, goodbye. But it's often challenging when you have a family that's sometimes a complex family and they're trying to plan together. You're going to have to read the rules carefully and see if it's appropriate that they waive confidentiality, they do consent to communicate. Where's another one where you could potentially, we were talking about this with the Wolf lecture, where there's a problem of confidentiality. Say in chat, or if you want to volunteer. You're going to work with other professionals. So that happens. The classic one is the client sours on the real estate broker. That's probably the most common one, is that you're doing the plan and it's with the real estate broker, and then all of a sudden that relationship kind of doesn't work anymore. And then the question for you as the lawyer and how you set up the relationship is, did you document that you were allowed to communicate with the real estate broker, and then inform the client that say, if any of the other professionals you no longer wish me to work with, please send me written notice that I shouldn't disclose anything, because this happens all the time, where sometimes that CPA they don't get along with anymore, the insurance broker they don't get along with anymore. Sometimes it's you, that you're the one who gets let go, but it's more of an ethical problem when it's other people, and you're still chatting about the case, and then they say, oh, I fired that person for whatever reason, and you have a few emails that were disclosing the plan to them. Technically, that's going to be a problem. So confidentiality comes up a lot. The other one that comes up a lot is conflict. Conflict comes up all the time. Lawyer shall not, without informed written consent from each client, represent clients that are directly adverse with each other. This happens all the time. The classic situation, which will happen in almost every one of your plans, where you need one of these disclosures and informed written consent, is oftentimes husband and wife come, or your husband and husband, wife and wife, on and on. There's a potential, there's not a current conflict of interest, but there's a potential. And the interesting thing, as we will get into, is even if you have community property, you are not required through testate planning or through the trust to give your half of the community property upon death to the other spouse. You could, if you wanted to create a real surprise, leave a will and leave it to somebody else. And then when you die and your spouse says, I'll take the other half of the house, it's community property, there's a will that leaves it to someone else, and they don't get it. You could completely do that. That's completely lawful. In divorce, again, it's dividing up the community property, so it's all about allocating. But once it's decided what's yours is yours and the marital union separated, it goes. Death is the same way. Once the person dies, the community property, the share that's the deceased parties, can be willed away. So because the client has that right, you do have to acknowledge to say, well, you could give it to somebody else, and this isn't necessarily you to you, you to you. You have to at least be aware that this issue exists. And of course, naturally, it's pretty uncommon that husband and wives or partners will do estate planning with two different attorneys, at an arm's length situation, but it could happen. Sometimes this happens with separated persons. Sometimes you do it this way, where people are still legally married. And actually, this is, again, sort of looking at all of these ethical problems where it's going to come up, is they say, you ask, you're not aware that they're married, and you say, "Are you married?" And they say, "Yeah, yeah, I'm married. I've been married a long time. I don't live with the person. I haven't lived with the person for years and years. All of the finances are separate." They say, "Are you divorced? Did you file a petition for divorce? Did you do any of that?" No, no, we just kind of keep everything separate. Um, you're going to need to go through this. And of course, you're not going to have a conflict, but you're going to have a complicated plan that you have a spouse with potential community property rights that's floating around. So there's that. The other one that is a major issue in estate planning, which is, again, you don't really see in litigation, because litigation usually, you're the lawyer and you're advocating the case, is independence. The lawyer shall exercise independent professional judgment and render candid advice. This is a major issue, again, in that hypothetical that I keep using, is the family comes kind of together. Is that, again, for, especially counseling older clients, but it's not always older clients. I had some clients that have overbearing parents. This is not uncommon in Silicon Valley. That I've had a few quite Silicon Valley success cases. The child, and by the child, they're in their 30s, is the multimillionaire, and they've never really gotten rid of that helicopter parent who still micromanages their life even though they're 30. As the lawyer, while the parents sort of bring them in and say, "Okay, we've cultivated him or her to be the millionaire. Everything's going along well, and now he or she needs the estate plan." Well, they got to go. So that implicates all of them: conflict of interest, confidentiality, and independent judgment. You need to determine, what does your client want. Older clients, older persons that you may be dealing with, any number of situations. That will be important. And then, of course, your role is a little bit different than pure advocate, where if someone comes to you and says, "Yeah, sue him to death. I want my money and I want it now." That's pretty easy to accomplish. But you're going to have, in planning, of having to come up with structures, come up with a design, and render advice. I had a classic one of a client that you want to tactfully, gently counsel them through candid advice, that was doing a trust, and basically was on his second marriage, had wife of the second marriage, had children of the second marriage. He had a substantial separate property that was going to be in this trust. And he said, who I really trust the most, who should be the trustee and who should manage this as my passing, is my former wife. I really trust her. It's like, it's going to be a disaster. You're going to put your former wife in charge of all of the assets with the new wife and the new kids. Yeah, there's not going to be any conflict with that, right? Tactfully, candidly, you say that's probably not the best design for you. Maybe you need a private professional trustee. Maybe you need something like that. But that's maybe not the best design for you. So rendering candid advice. The same thing with rendering candid advice. Some clients will want something very, very complicated. They'll want a very sophisticated structure. And as you, the lawyer, you have to size it up and say, are they really a size 48 suit? Do they want this huge thing? Or do you need something that's a little bit more efficient? So it's a little bit of a different role, where you don't second guess your client, and but what you need to do is give them options and analyze this as the counselor, where you don't just take the instructions and go. You need to give them the benefit of your experience and your learning, because that's why they hire you. So the ethical rules for independence actually allows this, that they say you should render this candid advice, that again, you're the lawyer, not the butler. So the last one is kind of a funny one. There's a special rule for gifts. You may have seen it if you've taken professional responsibility. Needless to say, shocking, you cannot prepare instruments of your clients that give you the gifts. You say, "Gosh, I have the best clients. Everybody wills me everything. Their trust said everything to the lawyer." That's an ethical violation. There is an exception. If you are related to the client, let's say you're doing it for your parents, you can do the estate planning for your parents, but there's a caveat that if you do the estate planning for your parents and all of a sudden you're the only taker, they've disinherited your brother and sister, that's going to be not okay unless you get what's called a certificate of independent review. They go to another lawyer, and the other lawyer says, "Wait, you really want to disinherit, Jimmy and Sandy? You only want Mike to get everything?" And then, in the ideal world, your parents say, "Yeah, absolutely. Yeah, I don't, we've lost interest in those kids." Fine. Okay, the other lawyer undersigns the certificate of independent review. Then, okay, there's not an ethical problem. But if you take more than the intestate distribution scheme, which we'll talk about next week, there's an ethical problem. And again, if the client's an outside client, there's going to be an ethical problem. And not something that comes up so much in ethical real life practice. But the funny thing is, this kind of comes up on the bar a lot. The exception is that while I drafted it, it gives the gift to me, but I get a 1/3. And the other, 1/3 goes to my brother and the other 1/3 goes to my sister. In that case, that's kind of the unusual exception where that's not a direct violation of the rule because you didn't get more than what you would have gotten if you did nothing. So something to kind of remember that pops up fairly frequently. It's a pretty popular twist on that one on the CalBAR. Obviously, we're not going to click on the link here, but the other thing to learn about or talk about for estate planning, especially this area, it's a little bit of an unusual area in that there's a lot of tradition to this and there's a lot of sort of customs. So if you've been in the law a little while, especially with older lawyers, Gilbert and Sullivan musicals, the light operas of the late 1800s from the UK are super, super popular. And if you're at a estate planning function with estate planning older lawyers and they serve alcohol, somebody's going to sing one of these songs. And one of the most popular ones is this one, which is basically the legal ethics rules set to song. So in your free time, do feel free to click on this link. You can hear Gilbert and Sullivan operetta there that will sort of run through some of the ethical rules. If you're curious about it all, probably the most common one enjoyed by lawyers is the operetta Trial by Jury. That one's all about lawyers. Very, very popular. And it's kind of the sort of tradition. The other thing that we'll talk about a little bit more next week, there's a Charles Dickens book, Bleak House, that's all about a probate case and is actually cited in the initial opening of Stern versus Marshall, U.S. Supreme Court case that was very significant about federal jurisdiction that basically says federal courts should not be anywhere near probate administration because there's nowhere in Article 1, Section 8 that gives federal courts any jurisdiction over probate. In fact, that's something that traditionally has always belonged to the states. And of course, what do they cite sort of in the colorful opening? They cite the case of the mythical case, Jarndyce versus Jarndyce, which is the Charles Dickens Bleak House case. So the reason I mention this is you see this kind of a lot, even in cases about estate planning or in practice guides and things, references to Charles Dickens Bleak House. That happens all the time. You'll often hear this as a slang, at the end that they say, oh, if at the end of this estate he's going to be Poor Richard. Spoiler alert, at the end of Bleak House, Poor Richard's the heir, but the estate has been used up through fees and costs and he gets nothing. So you're going to hear that a lot. If you're in the probate court, you're in Department 13, you may hear somebody say that. That means somebody who gets nothing because of too much estate litigation. So a little bit of the tradition of the practice. The other thing is this. Some of the things that I waste my time on, playing with this stupid meme, I spent way too much time than I needed to play with. And I just couldn't get the rendering right on the stupid social. I was trying to get legal in there, and it just wouldn't work. If you study psychology, the Dunning-Kruger effect, warning on this, Dunning-Kruger effect is, I would say in estate planning, is the place. What's the Dunning-Kruger effect? it's the potential, or I shouldn't say, or the psychological predisposition to overestimate your ability and underestimate complexity because you don't know about the topic. So when you initially see something and you say, you're watching the Olympics and you're watching the slalom and you say, oh yeah, I could do that. A couple weeks of training, I could go down the slalom, I could do that. And then you try it and then you've broken a leg and you realize, oh, that's really complicated. That's harder than I thought. Dunning-Kruger effect. So classic thing with estate planning, initially people will look at it and say, LegalZoom, you just put in the names and, the addresses, and then you just hits generate and print it. I can do that. Okay, that's fine. Dunning-Kruger effect. Didn't quite understand, because you didn't analyze the whole picture, you don't know very much about it, you overestimate your ability to do it. So be careful in this area because it is deceptively simple in the beginning, which is, in terms of joining the practice, great, because you can get in a little bit easier, you can start to learn, the odds of making terrible fatal mistakes that get you sued are low, you'll do all right. But with the understanding of Dunning-Kruger, I have to go step by step and make sure I double check, triple check everything, because a lot of the things are the Donald Rumsfeld unknown unknowns. I didn't know that that was a problem in the estate, and I didn't know to know it, and it didn't happen. Non-resident alien issue, the $60,000 thing, 40% mistake. Property tax. You two inherited a property, your brother and sister. You want a clear title. Sister, just give it to brother. Property tax reassessment. They inherited the property with their parents, the Cupertino property that the parents bought in the 40s. That's, they bought for $100,000. It's $1.5 million. Brother or sister transfers to brother. Entire property tax basis reassessed. They go from paying, let's see, $100,000, $1,000 a year for property tax, to going, 1.5 million, let's say it's assessed, to $15,000 a year property tax forever. You made a big mistake. So you can have a lot of these challenges by saying, oh, well, I didn't realize that the state property tax law works like that. Big problem. So that's something to be a little bit cautious with this area. Unlike last year, I taught bankruptcy. Bankruptcy is facially exceedingly complicated, so people tend to not pop in there. The funny thing, once you learn it, it sort of gets much more standardized. But estate planning is the reverse. It appears much more simple. It appears just picking and choosing the documents and filling in the form, but there's a lot more there. So one should tread a little carefully in the beginning. Perfect. It really depends how you're going to start your practice in this area. There are a couple of ways. One way is the hyper-diligence, is that if you decide, I'm going to go into this, I'm going to learn it, and you just devour all the information. You go through, the California Wills and Trusts, you read it constantly. You use CEB, CEB offers, wills, trusts, all those things. You pour through the whole thing, and you get pretty familiar. You can, for estates that, when you test, and we'll be talking about that actually in this course, that you say, okay, single house, $700,000, one marriage, children over 18, all U.S. persons, so no conflict in the family. They don't want to do any transfers. They just want to avoid probate. They want something efficient. And start saying, all right, this starts to look like an appropriate case for me. So scan the your California Wills and Trusts or your practice guide. Say, okay, this is looking appropriate. You can do this hyper diligence method, and then not choose or kindly refer co-counsel with more complex people. That's one way. The other way is START, which is actually the traditional way. And actually, anyone's a CPA? Do a test work? Uh, we're unique as lawyers that when you get your law license, you are out and you're a lawyer. CPAs aren't. You come out, you cannot, and you get your CPA license, you pass the exam, you have your degree, you can't do a test work. You have to have 2 years of experience under somebody who has the full attest license. There's a mentorship process. Anyone, sort of long, common law legal tradition in the UK and most common law countries, if you want to be a barrister, which is the lawyer who goes to court, you have to do a pupillage. There's no way to do it unless you study under a senior lawyer. In fact, it's the sort of whole system. And actually, we'll see in, well, if we can get it to work, the John Darst video, if you watch sort of UK they don't wear them except in criminal proceedings. Hong Kong, they wear it for everything. You could tell their seniority by looking at the wig. They wear the long full bottom wig. They're the senior counsel or the Queen's counsel. They have over 10 years experience. If they have the half wig, the bar wig, it's over 5. If they have the short cropped wig, they're new. They actually even, their dress shows it. So the second option that you have for learning this area is work with a senior person and absorb their knowledge, absorb the flow of the practice. And there's actually an Oscar Wilde quote on that says, education's a wonderful thing, but everything worth learning can't be taught. So that's kind of like the practice of law in that there's only so much I can give you, and you can learn from California Wills to Trust, the book. Some of it you have to go do, and doing it with someone senior is very good. The third one is kind of like a blend of the first one, is that if you are willing to co-counsel with more sophisticated lawyers who are more experienced. So this is very common. It's kind of interesting, and a good example of the estate planning practice being different. You will frequently work with other lawyers in estate planning. It's very common that you'll work with the business lawyer or the general family lawyer and things. So it does happen where you can work with another lawyer. So those are generally the more common ways. The classic sort of rocky areas to be careful with are taxation's one, disharmonious families, LGBTQ issues, if you're not familiar with them, those international issues. That's going to trigger problems. If they were like my initial hypo, you're probably going to have less of a problem. The other interesting thing with California, to the surprise of no one, is, just not to scare you, but is the situation. We are a broad attorney liability state. Something goes wrong, slightest problem, blame the attorney. And if you remember from contracts, privity of contract, you say, but I didn't sign anything with the beneficiaries. I signed it with the single guy, and he's dead. So how can the beneficiary sue me? California is very clear that in estate plans, potential beneficiaries are potentially intended third-party beneficiaries for malpractice, and they can totally sue you. So you can face litigation from people that you've never met, for clients that you had 20 years ago because of problems that later shook out. It's very interesting. I also am licensed in Wyoming. Wyoming has privity of contract. You can only be sued by the client or the estate representative of the client. So if there's 3 children, Johnny's the executor, and Johnny takes all, and the other 2 are think that you made a mistake, that's not what the parents wanted, and they want to sue you. Wyoming, they can't. There's no privity of contract, and it's a contractual-based relationship, and they're not intended third-party beneficiaries because they were X'd out of the will. They weren't there. California says, nope, they were intestate beneficiaries. They can sue you. So it's a little bit of a problem. There's broad liability for that, so to be on the lookout. So any other questions before we get into, and we actually kind of round out where we are for the rest of the night. We're getting towards the end. So any other questions about estate planning in general or the ethical rules? Yes, yes, and actually I'll just do a little bit on it now just to kind of, introduce it or as a potential problem. This is a very Silicon Valley, California problem with estate planning. And this is where the problem becomes a challenge for you as the practitioner because the problem is not the probate code. The probate code says if you're the heir or you're named the beneficiary, you take. We don't care. You could be from Mexico, China, Canada, the moon. You take. We don't care. It used to be a problem under intestacy back under the old codes that if you were a non-legal person, you could not take. That's, of course, been abolished for a long time. So there's no problem in the California code. The problem's the estate tax code. So where does this come about is the estate tax code draws a distinction between U.S. persons, and the distinction is, which we actually will have a little bit of a class on it, but it's fun to talk about now, on the concept of domicile. So if any of you have dealt with taxes, income tax, and I'll display a little bit of my age. I'm old enough when the IRC, the code, used to come to you in books, and you get books that was the IRC, and one volume was income tax, and the other volume was estate gift GST, and then you ended up with excise, and then you ended up with import export, and you had all these different books. The rule for who is a U.S. or non-U.S. person for income tax in book 1 is totally different than book 2. So there's a problem. The other problem is that in book 1, who is a U.S. person is a mechanical test. Substantial presence, 183 days. You're here 183 days in 1 year, or in the last 3 years aggregated, you're a U.S. person. You pay the U.S. income tax as if you're a U.S. person. If you are using the estate gift tax, the question is domicile, which is intent to stay. So if you like criminal law and the mens rea of the murder, we have a mens rea for estate tax. There's a great case, Khan, about this situation. The person was fairly wealthy, a Pakistani man, accrued a lot of wealth in the U.S., green card holder. He wanted to go back to Pakistan for medical treatment. He goes over there. Obviously, he went there because he was really sick. He got worse, and he got stuck there. And he got stuck there a good long time, and then he got stuck there forever because he died. So he was in Pakistan, lost the green card, was not a U.S. permanent resident, died in Pakistan, interred in Pakistan, and then, of course, the IRS, because they're the IRS, say, gotcha, estate tax. You're a non-U.S. person, 40%, minus $60,000. And the family argued. I say, whoa, wait a minute. The test is domicile. It's intent. It's not a mechanical application of the 183-day rule and all of these, the green card rule or the citizenship rule. He died, of course, according to the family story, longing to return to the U.S. He still had his properties. He didn't want to stay in Pakistan. He stayed in Pakistan because he was so sick, he couldn't come back. And then nature took its course and he died. He died, clutching an American flag, pointing, east. They say, all right, facts and circumstances. We had a trial. The trial says it's pretty persuasive. Yeah, he died wanting to come back. He's a U.S. person. Domicile actually prevails. Weird in taxes that you have a non-mechanical rule, but that's the situation. So this becomes very muddy in Silicon Valley practice because we have H-1B people, we have B-1 people, we have OPT people. I had an A-1 person, which is a diplomatic visa. That's bizarre. You have all of these different things mixed together, and it can be a big problem with non-resident aliens. Now, I'll give you a little bit of a story since we have a little bit of time, sort of a fun one on how we start to spend a lot of time in this practice. Kind of a classic example and a good light introduction into the estate and gift tax. The estate and gift tax is harmonized and coordinated. It's the same tax system, and it's to catch gratuitous transfers. So again, as you could kind of think of, if the gift tax wasn't tied to the estate tax, if I think, oh no, I don't feel so well, I give it all away, and I avoid the estate tax, of course that makes no sense, because if I just conveyed everything, then everybody would just convey everything before they die. So the gift and estate tax are harmonized. Things that you gratuitously transfer during life lower the lifetime exemption, which we'll talk about. So they're harmonized. So you have to be careful with, of course, passing things at death, passing things through gift. So to the story, just to set the stage, is that the estate tax, gift tax are the same, and that non-resident alien issue of the $60,000 exemption applies to gifts too. So client profile. We get sort of a frantic call from a client who was, as we were talking about before, very, very difficult client. My receptionist just, like I said, this person's calling like repeatedly. I'm on the line with the person and they're calling again. Problem. So the client, what's the problem with the client? They've got notice of assessment, notice of lien, 90 days to pay for 40% of the value of their property. So the property was like $1.5 million. So it's, like $600,000 that they say you have 90 days to pay. And we place the lien, as the IRS says, we've liened the property. So we see, this is a weird issue. Okay, come down to the office. Let's figure out what's going down here. So of course, person comes down, and obviously they don't know how to park in downtown, and they're screaming at the receptionist. So we all go down to try to fish the client out of 3rd Street in Santa Clara, and the client shows up in literally the Nicki Minaj car. So it's literally a hot pink Lamborghini on 3rd Street. They're like, you joke, I didn't realize Nicki Minaj was Chinese, but alas. So she gets out of the car with literally the doors, like, the gull wing doors open up. And we think this is going to be a weird one. And no doubt it was. So comes up, what's the story? So this is the story. Chinese speakers, there's a joke. This person's the Fu'er Dai, the wealthy single generation. Basically, the person who inherited, or the family has massively spoiled them under the one-child policy, and they are sometimes shockingly wealthy. That's her. Somehow, she got into Stanford. Shockingly wealthy, getting into Stanford. This is, again, before the USC scandal. Maybe explains that. So somehow she's got into Stanford. Mom and her come here. They're driving around because she got into Stanford. She sees the Stanford dorm and says, look, I'm not living there. No way. So they're driving around Menlo Park, and they see, a nice little house there. I think it's a, sort of small place. And there's a sign that says, Bill Jones Real Estate, call. So she says, Mom, I want that. Buy that. Just get that right now. I'll live there. It's close. So, of course, Mom calls Bill Jones and says, yeah, we want the house. True story on this. It was funny. He says, oh, I'll come out right now. I'll show it to you. She says, no, I just want the wire instructions. Tell me where to pay. I want the house. They didn't look at the house. They just wired $500,000. So they wire the $500,000. And of course, again, ethical problems. Again, this is pre the lawyer being involved. But if you start working with clients, ethical problems, anyone with a real estate broker's license thinks, I could double end this transaction. I'll represent the seller, I'll represent the buyer, I'll get both commissions. Oh, it's going to be great. We'll close this. I'll make so much money. They don't even want to look at the house. Perfect. Huge problem as we start to see. Of course, the wire's going to come from Mom. Mom takes title. How many times has Mom been in the U.S.? Well, one. maybe one or two other times for a vacation. She's a non-resident alien. She came on, with the tourist visa. So no status. Mom, takes title. So, of course, she's enjoying Stanford, on and on and on. And she gets the wise idea that says, maybe mom shouldn't be on title anymore. I think I should be on title. And I got on the internet, the font of all good legal knowledge, and there's this thing called a quitclaim deed. So when mom comes back, I'm just going to print out the quitclaim deed. We'll go to UPS store, stamp, 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 and it'll be my house. No problem. Great, super. So they go to, mom comes over, stamps the quitclaim deed. They go over to the San Mateo County recorder, and here's a twist: local practice. Again, this is being in areas for a long time. San Mateo County and San Francisco County, and not Alameda County and not Santa Clara County. When you go to record a deed, and this is true of all California counties, there's something called documentary transfer tax. To record a deed, there's a tax, there's a stamp duty on it. Of course, they get there, the deed's not kind of fill out right, and the recorder says, you got to pay the documentary transfer tax. And on a $1.5 million property, that's about $10,000. That's a lot. So they say, well, I don't want to pay that. And it's a gift. And the recorder says, well, fine. Okay. If it's a gift, there's an exception for the documentary transfer tax. And San Mateo and San Francisco County, we've got a special form for that. Because, we get mad when you don't pay the documentary transfer tax. So they pull out the form. And what's the form say? The form says, this is a gratuitous transfer from grantor, mom, to grantee. And the fun language, they say, I have read and understood Title 26, Series 2000 to 2600, and I knowingly, intelligently, and voluntarily make this transfer with full awareness that there may be gift tax consequences. I swear, the foregoing under, penalty of perjury. Sign this, $31, stamp, 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 stamp. And San Mateo County immediately throws this into the fax to the IRS. The IRS reviews it and says, Wei Xiaojin, what was your status on May 20th, 2020? Of course, they don't have to ask. They just ask Homeland Security, USCIS, that checks it and says, oh, visa. And they say, perfect, 40%, because it's the simplest tax case you'll ever have. Exhibit A, the deed. Exhibit B, USCIS, the entrance stamp, the I-94. So you have those two things, summary judgment. That's all you need. You say, see, transfer A to B. Status at the time, non-resident alien. Tax, 40%. Summary judgment in my favor. No more talking. So needless to say, that's what they assessed. They claimed, claimed rightfully, that the gift tax was due because it was a non-resident alien transfer to anyone. So, naturally we fought it, and actually the IRS appeal settled the matter, and the claim was that it was a botched capital gains issue. There was a botched sale, and that they paid the capital gains tax instead. That was a long shot, but it worked. So there's kind of a story about how this can happen. It is a ubiquitous problem. It's just everywhere in the Silicon Valley. And then we'll talk about the specifics of techniques to try to solve it. But it's definitely something to be on the lookout for. If it's a property outside of the country, it's a non-US asset of a non-US person. So no taxing. The US doesn't have jurisdiction over that person. So, but there's a problem. If you have a US citizen owns property abroad, that's subject to the estate tax. It's very hard to determine in terms of auditing, especially real property. So in some areas, I do a lot of practice in PRC China. Well, I don't practice in China, but my clients are from there. Figuring out a land deed from Chengdu is going to be impossible. But Hong Kong, they're going to know. They're going to figure that out. Japan, they'll probably figure that out if it's large enough. South Korea, they're going to figure out. Europe, probably figure out depending on where they are. If you're a high enough net worth, or actually I should say net gross worth individual. The other thing that's just an aside is FATCA. Is anyone familiar with FATCA? Yeah, if you have foreign bank accounts over $10,000, you have to disclose them annually on your tax return and pay the capital gains. Hong Kong, that's been a huge issue. The U.S. Really attacked and busted up HSBC and Standard Chartered, and basically HSBC just faxes everything to the IRS. So if you think, my asset protection plan in Hong Kong, the IRS knows. They've taken a look at that. Singapore, pretty similar. Why? Because HSBC, Bank of Singapore, needs to access the U.S. Treasury discount window. No matter how wealthy that client is, they're not going to risk that. So they just fax it over. So that can be a problem. Again, like if you have U.S. clients with substantial holdings abroad, you have to figure that out. And there's a planning problem because you say PRC China's classic one. Beautiful, perfectly crafted U.S. estate plan. Article 34 of the Chinese Succession Act says they do not, will not, and never will accept any estate planning documents that are generated outside and not under PRC law. So when you wave that will around or you wave that trust around, they say our law specifically rejects that. So not going to work. Canada will accept U.S. documents. Another classic example, France, Germany, Netherlands, Switzerland, Italy, basically any continental European, Japan is another one, Taiwan's another one, continental civil law country, and you say, I did a trust. Say, what's that? I don't know what a trust is. I say, the trust, where you separate legal ownership from equitable ownership, and you have a title trustee, beneficiaries, and the settlor. So we have no concept of how property works under that method. Continental law does not conceive of property that you can split the legal and equitable title. It just does not work that way. So when you have your fancy trust, they will say this is something that our law simply does not do. So you're going to have a problem. Next week, we're actually going to talk about that for intestate succession because that's a fairly major issue. So the continental legal system is very different on that. And there's one state in the U.S. where you also have that problem. And when I don't think anybody's going to expect to practice out there or have much contact. State of Louisiana is a civil law system. So the Louisiana, they call it the Code of Succession, looks like the French system. It is not a common law mindset. So things like the trust you can do, but you really have to fight against their code because their code is designed very similarly to the Napoleonic Code, which does not conceive of property getting split between legal and equitable title, which common law, that's sort of the magic of the common law. That's how we've been doing that, for 600 years since the Statute of Uses, splitting legal and equitable title. They don't. So there's some planning issues when you deal with things like that. So any other sort of fun questions before we get to just our last bit? Well, hearing none, I'm going to pop over to the last bit. This is really just a summary to sort of preview what we're doing. So what are we doing? What is estate planning? So estate planning, just like this quote, it's an arrangement for the conservation, investment, use, management, and transfer of a person's property, both during the person's lifetime and after the person's death. So estate planning, you're trying to figure out how to preserve, conserve assets, how to arrange these with investing. Again, sometimes that's going to be done by another professional. Use, other professional, management, sometimes other professional. You can see with investment, financial person or insurance person, use, potentially real estate broker or private family office or on and on. Management, financial manager, bank, all those things are there. Transfer, that's again, real estate broker, title companies, all of these different things are going to come up. That's what we're trying to do. We're trying to arrange something to protect, conserve this property, move it over time, either at death or during life, where the person wants it, in the way that they want, in a way that is received in an as optimum a way as possible, that does not get hung up on things. So again, different than litigation where we sort of fight to win. Win on this is that no problems arise. Our package gets to Des Moines with no hiccup. I don't want anything. I want that to. I'm going to put that on the conveyor belt. It should pass through TSA. It should get onto the plane. The plane should fly carefully to Des Moines. It gently flops out onto the conveyor belt, and the receiver picks it up. That's what we're trying to do. But of course, there's a lot of steps on the way. So, what are the objectives? What are we trying to do? In the broad scheme of things. One of the first things that we try to do is create an estate where none, if there's one that doesn't exist, by, of course, maximizing opportunities for savings and investment. So creating an estate, of course, while we're living, there's an estate, but oftentimes we will contain that estate instead of using a will. We'll talk about wills next week, using, let's say, a trust, a revocable trust that captures everything. Of course, for sophisticated estates, we may part some of that out with irrevocable trusts. But one of the parts is creating an estate. Why do we create an estate? We have to have something that we can manage, something we can move with authority. If there is an estate, you try to conserve the estate, try to prevent waste and mismanagement, improve investment techniques, and optimize tax savings where you can. You also want to create conditions where the client can enjoy the estate and that they have as much freedom as appropriate in accordance with their preference and lifestyles. Again, I have a lot of clients, sometimes new immigrant clients, they'll actually give the title to their children. Terrible planning. But they give it to the children. You don't own it anymore. In addition to the gift and the basis swapping problem that's just a disaster, you lost control over it. So, maybe not ideal. You transferred it, it got there, but maybe not in the right way. Same thing, joint tenancy. Joint tenancy, often a terrible design, because I had someone, oh my God, put the 17-year-old son on title and bought him a new car. Luckily, nothing happened. But boy, that person gets in a wreck and gets sued, you lost half of your property. But they say, oh, I just did the joint tenancy deed just for estate planning. It was just going to pop over. No, joint tenancy made him a present interest holder. So when he gets sued and loses, they're going to get half of that property. So that was a stupid design. So again, misusing the instruments or using the wrong instrument for the wrong problem. So one of the other things that's very important for estate planning and is also critical for client management, this is kind of the, when you deal with clients, focus on this, planning for incapacity. Estate planning for while you're alive to help you. Most clients, I'd say, dealing with pure mortality, a little uncomfortable. Plan to live, and plan the plan with living as a major part of the plan. What happens if one loses capacity, or even doesn't really lose capacity, but gets to an age where some management needs to be devolved to other family members? So that's a major part of trust planning. Doesn't work at all with wills, you'll see. Will power of attorney combo, maybe. We'll talk about that. But trusts are usually where you plan for this. And there's a lot that can be done there to achieve client wishes and avoid conservatorship, which is basically, an example of COVID. I don't know if you took a look at the Superior Court website. Criminal law was still operating during the court closure. Conservatorship was still operating during the COVID issue. So they often were wheeling in incapacitated seniors into the probate court. So unfortunately, they had to sit there through the indignity of the court determining, wow, they've lost capacity. They look like they don't know where they are. We're going to take away their civil rights. Undignifying. Most people don't want this to ever happen to them. Planning avoids this. It's not a pleasant thing. We serve, I use my law firm, and I speak Chinese. We're court-appointed attorneys frequently for Chinese persons who are facing conservatorship. Not good. You don't want that to happen. Jobs planning attorneys to make that not happen. That's probably a great gift of your skill to your client to avoid that from ever happening. The last two, of course, transfer the property as they like, arrange transfers, because again, you're moving from generation A to generation B, sometimes to generation C, sometimes to charitable trusts, sometimes charitable foundations, on and on, moving things. And then, of course, the final disposition, when the person passes, it should go across to the person they want. Big four. So what do we use to do this? And just a very light brush. We're going to have literally a class on each one of these. Wills. My last will and testament. We'll see, and this, I really have to cue up the video for this because you have to see the episode of Dallas where they read Jock's will, because it's like the thing of the episode. And whoever advised Dallas did a great job of Texas law, because it's pretty much spot on with Texas law and how you deal with a will. A will is an essential part of an estate plan. It is not the modern vehicle for estate planning. Why? We'll see, because it causes probate. And California, we lawyers wrote the law, and we charge massive fees for that. New York, it's consensual. It's generally around $1,250 to probate a will in New York through the surrogate's court. So New York does a lot of wills. Texas, the same way. Probate a will in Texas, $1,000 probably. There's no percentage fee. Everybody does wills in Texas. Wyoming, kind of the same. A lot of people use wills. California, no, because 4% of the first 100, 3% of the next 100, 2% of the next 800. Wow, that adds up really fast for not a lot of legal work. Probate, good practice area. You can think about it. So we generally don't use the will for that. We do use the will, those of you actually in personal injury, appoint your personal representative. Wrongful death lawsuit. My executor, something happens to me, I tell my executor, sue the hell out of those people, just as an academic exercise. Of course, because somebody needs to be appointed to handle, that's not property necessarily, it's a right that I had to handle that. Guardians for minor children. Huge non-resident alien international issue. Needless to say, a lot of persons are here in the U.S., husband and wife, or other combinations, have children here. The closest relative is in China. That's who they want. They want grandma, grandpa to be the guardian. They don't know anyone else here. You need a structure through estate planning and sophisticated planning to address this. Because do you think, husband and wife, parents have passed away, that 191 North First Street is going to send a U.S. citizen, and this often happens, this is a very common combination, U.S. citizen child to communist, China virus China? No. They're going to go into the temporary foster care situation. So you need to design something that has temporary guardianship, an ability to then have the foreign person's petition. You have to set this up before there's a problem. Hopefully it never happens. But without setting it up, there's a major issue here. So we'll set guardians. They do a few other things that we'll talk about. Trusts. Trust is where we're going to spend a lot of time. That is the modern California, Nevada uses it too, a few other states where it's really the prime planning. The trust, the revocable living trust, is the vehicle that we get property from generation A to generation B. Because It is non-judicially supervised in most situations. It's more efficient. It also enables during life administration. If I lose capacity, my trustee can administer for me. Will, you're still alive, doesn't do anything. Say, let us know when you die. Trust, though, will have provisions for incapacity to manage assets. So trusts are really the major vehicle. Revocable living trusts. There are also, the irrevocable living trusts, or irrevocable inter vivos trusts, as the Latin goes. Those are highly sophisticated planning instruments. We're not going to talk about too much, but I am going to try to give you an introduction to the irrevocable life insurance trust, because you'll probably see that in practice. And it is a little bit complicated, but it is very common. So you're going to need to know about that. So that's about trusts. The other thing that we'll talk about is durable powers of attorney. That creates an agent. So it's a principal-agent relationship. I pass power of attorney to my agent. And the durable part means is that after I lose capacity, it's still good. But what if I die? It's no good. It's gone. The number of people in your practice that are going to come after someone passes away and brings you a power of attorney, it's going to happen. You're going to get a couple of these a year. It's no good. It was fine while they were living. If it was durable, it was fine while they were living without capacity. But once they're gone, the power of attorney is gone, because it's a principal agent instrument. And when the principal is gone, the agent is automatically discharged. So there's no instrument there. So again, knowing the instruments, preparing a power of attorney, thinking it's a will, wrong use of the instrument. Preparing it as principal agent for incapacity, I may have dementia later or something like that, perfect, works great, that's what it's for. Similarly, advanced healthcare directive. That's what we call it in California. We call it the Advanced Healthcare Directive. This is where we set a healthcare agent. So if I don't have capacity, I can give my agent the ability to make medical decisions for me. And then number two, I can specify my end-of-life care preferences if I should happen to have them. I don't have to. This gets all mucked up because other states call this all kinds of different things. Living will, healthcare power of attorney, all these different things. Even advanced healthcare. Healthcare is sometimes spelled differently. Other states combine it into one word. So you see this in all kinds of different variations. But these are the big four. This is, there's accessories that we'll see. The will, if they are from a treaty country, maybe you'll prepare a will with the international certificate. Trusts, of course, there's any number of variations. GRITS, GRATS, GROTS, UniTrusts, ILITs, there's any number of acronyms of what you can do with those. Powers of attorney, of course, those durable, non-durable, and then there's some special ones. Title companies produce them specifically for real estate. They're one transaction only. They're one and done power of attorneys. And then the healthcare directives for that. So those are sort of the big four. And then this kind of my parlance, the little seven. These are less used, but are certainly around. Disclaimers. Disclaimers. This you may not have seen. If you took wills and trusts, though, you will have seen this. Disclaimer is, Grandpa gives me 500 herd of cattle. Say, don't want it. Disclaim. I don't want that. Aunt gives me that odd painting of the dolls. Disclaim. Don't want that. So disclaimers can be used strategically in planning an estate of saying, okay, some things will be granted to that party with the understanding that they may disclaim it so it drops down to somebody else. That happens a lot. That when we talk about the marital bypass trust, that operates heavily on the surviving spouse using the disclaimer to knock property down to the kids if they want it to be sold immediately. So that's pretty common. Powers of appointment. Has anyone ever heard of this or your hand raised? This is a little bit bizarre. If you took wills and trusts, you may have heard about this. This is an old structure from the English common law, where basically in a will, though it can sometimes be in a trust, but usually it's in a will. I say, gosh, I don't know what's going to be the situation when I pass away. I really trust, my friend Jim. I'm going to give Jim a limited power of appointment. So I die, and Jim's the king and queen maker. Limited, he can't choose himself, but he can dispose of the assets as he wishes and basically do a grant and say, okay, Michael's passed on. All right, Jenny, Tammy, Carla, Catherine, Christina, on and on and on. You each get a share. Done. It's granting a right to dispose of the estate to someone else. It's rare, but they exist. They float around, and sometimes someone will have a power of appointment. A general, they can appoint themselves. Sometimes they'll have a limited. It happens. Sometimes strategically they are used, but that's the aircraft carrier of sophistication for planning. Life estates the same way. When you took property or real estate, there is such a thing as an estate in land. So there's the fee simple absolute, the fee simple subject to limitations, and there's the life estate. Classic California, you see life estates a lot. What is the life estate? The life estate is where, which would be classic, I give someone the right to reside and live in a property for their entire life. But when they go, what happens to that property goes under my decision. They can't will it or devise it to anyone. They only have the right during their life. Of course, they can sell that, but as soon as they die, whoever's in there, the tenant or whomever, or the purchaser, gets kicked out because the estate reverts. So there's the reversion in the life estate. These, to correct what I said before, not so common in California. You see them all the time in Texas practice and some other states that took their community property system from the French and not the Spanish. So California, we tended to take a lot of community property from the Spanish. They didn't quite have this concept. The French, so you see it in Louisiana law, you see it in a lot of Texas law. Kind of as you get west, it drops off. Arizona, you don't see it so much. They have this concept that the surviving spouse often gets a life estate or a partial life estate in the separate property. So like, in California practice, we have our main, house, and then we have, let's say, the vacation house that's wife's separate property. Wife passes on. California is going to devise that. That's going to put it to other people. Surviving spouse is only going to get a fraction. But in Texas practice, the surviving spouse is going to have the right sort of ownership for his or her life for that piece of property. So that's the life estate. You see them around. Co-ownership agreement or arrangements, joint tenancies, make sense for bank accounts, sometimes husband and wife, makes sense for some things. Joint tenancy, you often see joint tenancy misused. It's sort of the $30 estate planning on the cheap. That has a lot of problems if that's done incorrectly. Just as an aside in our last 2 minutes, California, you are allowed to sever joint tenancies. So if I own as joint tenants, if I just walk down to the county recorder and record a severance, it's now tenants in common. It's not like, you may have heard, like a tontine. A tontine is sort of a life, is sort of a pool. It's prior to life insurance. It was kind of a hokey life insurance thing. We all join in on the tontine. None of us can break a part of it. And the last man standing gets all of it. Joint tenancy is not like a tontine. I can split out my share and pull it out. So it doesn't work that way. Life insurance, huge part of this. Dealing with how you fund an estate. You have $1 million house with an $800,000 loan. I can get that to the surviving spouse. How's he or she going to pay for it? There's no problem. So you're going to often have life insurance planning on this because you as the lawyer may be able to get things over there, but you're just getting partial assets that are all encumbered. And that's not going to be, a lasting plan. Pension profit sharing, huge part. 401k, 503b, on and on and on. IRAs, lot there. Multi-party accounts, you're going to have a lot of that. So these are sort of the little 7 that you kind of think about. So you think about, okay, will, trust, power of attorney, advanced healthcare directive, we nailed that. These are other tools that will mix into the planning to make the good plan. So, of course, I'll leave you with the Family Guy quote, the Peter Griffin quote. All right, all the pieces are there. Somebody make something out of that. So that's what we're going to do. We're going to try to make something out of that. So we're going to try to take those pieces and put them together by knowing what they are, knowing what they do, and create the plan. So when we put together the binder all together, we will have something that works, and we'll have the plan. So thank you for bearing with me for the technological problems. We will solve that next class because you have to see the reading of Jacques' will, and then we have to prevent the computer from exploding. So if we do those 2 things, we will have a success, which I think we can do. So let's do that. I will see you next week. Be well and be safe, and good night. We'll see you.